Hello, everyone. Welcome back to the U.S. Immigration Hub News. If you've been watching immigration developments closely this year, you know 2026 has already brought a series of policy shifts, enforcement updates, and administrative decisions that affect immigrants of all legal statuses. This week, a new change is drawing attention because it impacts green card holders nationwide. Not as a single dramatic announcement, but as part of a broader set of rules and eligibility changes that will influence everyday life, work, business opportunities, and how lawful permanent residents interact with federal programs going forward. In today's update, we're going to break down what the change is, where it comes from, and what it means for people holding U.S. green cards. Right now, this is not about speculation. We're pulling from verified policy moves and published reports so you understand what the shift actually entails and how it connects to the immigration landscape in 2026. If you are interested in this topic, please stay tuned until the end of the video. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now, let's get into the video. The change that is getting widespread attention this week isn't a new immigration law passed by Congress, and it isn't a DHS memo that rewrites fundamental immigration categories. Instead, it comes from a policy shift announced by the U.S. Small Business Administration, effective March 1st, 2026, that changes eligibility for government-backed loans for lawful permanent residents. According to an official notice, the SBA will no longer allow green card holders to apply for certain SBA-backed loan programs, a significant shift from recent policy that had permitted limited non-ITIZAN eligibility for these programs. While this change is not an immigration decision by U.S. Citizenship and Immigration Services or Department of Homeland Security, it's directly tied to broader executive policy priorities and has implications for green card holders because SBA-backed loans are often an important financial resource for entrepreneurs and small businesses. Under the revised policy, green card holders will no longer be eligible to use SBA backup guarantees or certain SBA loan programs, marking a clear shift in how federal resources are being allocated under the current administration. It's worth underscoring that this is a policy change by the SBA, not a revocation or review of immigration status. A green card holder's lawful permanent resident status remains unchanged by this SBA decision. But this shift does illustrate how administrative changes outside of direct immigration law can affect daily life for green card holders in 2026. To put this in context, it's part of a larger pattern under the current administration that includes more aggressive enforcement priorities and tighter eligibility standards across federal agencies. National reporting has documented that immigration enforcement activity has increased substantially with the number of individuals in detention rising and interior enforcement operations remaining robust. Some of that enforcement focus has prompted public debate and scrutiny. Recent reports indicate a rise in interior actions and a significant expansion of immigration detention capacity, which civil rights advocates describe as harsher and less accountable than in past years. These enforcement trends set the backdrop for administrative decisions that reach beyond deportation or status issues toward how lawful residents are treated across federal programs. Another related development has been an ongoing pause in certain immigrant visa processing categories, which can indirectly impact green card holders who are sponsoring family abroad. Reports show that immigrant visa issuance for nationals of certain countries has been paused pending further guidance reshaping how families reunite across borders. While this does not affect someone already living in the U.S. with a green card, it does illustrate how federal policy approaches are now interconnected across benefits, enforcement, and eligibility. It's also important to recognize that federal enforcement agencies are using shared data sources to inform operations that touch on lawful residents. For example, policy changes in data sharing agreements between health data systems and immigration enforcement have raised questions about how information is accessed and used in immigration cases. This type of coordination reflects a broader administrative strategy to use available federal information systems more actively in enforcement contexts. In a practical sense, what should green card holders take from this? First, recognize that not all changes that affect lawful permanent residents come through USCIS or DHS directly. Policies adopted by other federal agencies like the SBA can create real impacts because they change eligibility criteria for federal resources that many people rely on. Second, these policy shifts are part of a policy environment that is more rigorous and less differential than in recent years. Enforcement arms of government are operating with expanded resources and stronger mandates. While this often focuses on removal and detention for non citizens without lawful status, it also changes how other agencies approach risk, eligibility, and compliance for those within the system. Third, administrative policies can shift without affecting immigration status itself. A green card remains lawful permanent resident status unless formally revoked or abandoned under immigration law. Changes outside of immigration, such as how an SBA loan is administered, do not by themselves change your status, but they do shape how lawful residents participate in broader civic and economic life. For example, if you are planning to use an SBA-backed loan to start or expand a business after March 1st, 2026, that option will no longer be available under the revised policy. Green card holders will need to look to other financial resources or private lending instead. If you're watching this and wondering what this means for other areas of immigration and public benefits, another policy area worth noting is the evolution of public charge guidance. Proposed ruling could expand how public benefits usage is considered in immigration eligibility, potentially affecting green card applications or naturalization in the future if finalized. At this stage, these proposals are not finalized rules, but they do signal the direction of policy thinking within the administration. It's also worth noting that enforcement practices and public reaction to them continue to be a significant part of the landscape in 2026. Policy reporting and community responses to enforcement operations, including protests and legal controversies, are ongoing. Taken together, these developments illustrate a broader policy environment in which green card holders need to be informed not only about immigration process changes, but also about how administrative policy shifts across federal agencies can affect opportunities, eligibility criteria, and personal planning. Another important angle to keep in mind is how changes like this can influence long-term planning decisions for green card holders. Even when immigration status itself is not directly altered, many lawful permanent residents make decisions about starting businesses, purchasing property, sponsoring family members, or applying for citizenship based on assumptions about access to federal programs and stability. When eligibility rules shift at the administrative level, it can require people to rethink those plans, not because their status is in danger, but because the surrounding framework has changed. This is also a reminder that immigration policy does not operate in isolation. Decisions made by agencies outside of USCIS and ICE can still shape the lived experience of green card holders. While immigration law defines who may live and work permanently in the United States, other agencies determine how those residents participate in economic and civic life. In 2026, those boundaries are being drawn more narrowly, and that reality affects everyone holding permanent resident status, regardless of how long they have lived in the country. For green card holders who have been in the United States for many years, this shift can feel unexpected. Many people received permanent residence at a time when federal programs were more broadly accessible to lawful residents. The current environment places greater emphasis on citizenship as the dividing line for certain benefits and opportunities. While this does not change the legal value of a green card, it does change how permanent residence functions in practice. It's also worth noting that policy changes like this often do not arrive all at once. Instead, they tend to unfold gradually across different agencies and programs. One adjustment may affect loans, another may affect benefits eligibility, and another may affect compliance reviews. Over time, these incremental changes can add up, which is why staying informed, even when there is no immediate action required, remains important for lawful permanent residents, for families, and individuals navigating this environment. The most practical approach is awareness rather than alarm. Knowing where policy lines are being drawn helps avoid surprises later, especially when applying for benefits, filing future immigration applications, or making long-term financial commitments. Understanding these shifts early allows people to adjust plans thoughtfully instead of reacting under pressure. As 2026 continues, additional administrative updates may follow this same pattern. Changes that do not alter immigration and status directly, but that influence how permanent residents interact with government systems. We will continue to track those developments closely and explain what they mean in plain terms, so viewers can make informed decisions without confusion or misinformation. We will continue to monitor this SBA eligibility change, enforcement trends, public charge policy developments, and other administrative updates that affect green card holders in 2026, and we'll break down what these mean for your immigration journey in plain language. That's all we have for this bulletin. The U.S. Immigration Hub channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas, such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for watching, and we'll see you in the next